Please rise. And I will read the jury's decisions. For verdict form 1, count 1, aggravated murder, State of Ohio versus Erica Stefanko, we, the jury, being duly impaneled and sworn, find the defendant, Erica Stefanko, guilty of the offense of aggravated murder as charged in the indictment occurring on or about June 20th, 2012 through June 21st, 2012. And I do have 12 signatures. This says we do so on January 31st, 2024, with 12 members of our jury concurring. On count 2, murder, we, the jury, duly impaneled and sworn, find the defendant, Erica Stefanko, guilty of the offense of murder in the commission of an offense as charged in the indictment occurring on or about June 20, 2012 through June 21, 2012. We do so on January 31st, 2024, with 12 members of our jury concurring.
I knew from the get-go, Detective Hitchens knew from the get-go. When I was at my daughter's grave, when they put her in the ground, he said, I'm never going to give up, Kim. He never did, and I never would. And thank you to everyone that's been here for me, my support, my help, my family, my friends, and I'm so sorry. I had to put everybody through this, but Ashley needs to rest. Ashley needs to rest. I need to rest. I need to go on. And we got her. We got her. Thank you, Lord.
It's been a long process to finally get this answer today.
Yes, we did. The answer I was hoping for, and the answer I do in my heart. Because God will prevail. Justice has prevailed. And my daughter can finally sleep. You won't hurt her no more. You won't hurt her no more.
Thank you. Thank you.
Thank you. You all.
Thank you. Ooh, goodness me.
Hey, oh, you got my money, right?
Keep going. Here.
Keep going?
I said keep moving on.
Oh, I'm moving on.
Yeah.
It's time for me to be happy.
Yeah, time to be happy.
I need to move on. I need to move on. I need to have a life. I've never had a life. Never had a life. I'm just so happy.
What does this mean to the rest of your family?
Oh, I'm sure. They're ecstatic. They're having a party. We're all going to have a party online. I don't care. We'll all come together. Our family will be together again. What little I have left. Thank you, Mike, for being there for me. You've always been there for me. You're my rock, and you see me through this all, and I can't thank you enough. I'm sorry, I'm crying.
No, do not apologize. Goodness.
I'm just ecstatic. I just
Got the answer that you were hoping for.
the answer that I do with my heart. I knew it was all gonna come together.
Congratulations.
Thank you.
Trying to get some sleep as well. I know you need
Oh, I will get some sleep.
Oh, yeah, you need that sleep. Yeah.
I don't know about the night terrors. They're not gonna quit, but it's okay. Ashley will see me through this.
She will. She's with you.
She can finally rest. That's all I gotta say.
Thank you.
Thank you. Thank you.
How would you describe Chad as like running the family?
He was in charge. Kind of like a general with his troops, I guess.
Okay.
He was very focused on discipline, and he was violent.
Okay. I don't want to get too much into it, but was he abusive to the children?
Yes.
Okay. Was he abusive to you?
Yes.
Okay, we're going back on the record. State of Ohio versus Erica Stefanko. It is 2:04 p.m. And neither party has anything further to say.
No, Judge. Thank you.
No, Your Honor, not on behalf of the defense.
Okay. Mrs. Stefanko, you were convicted of count 1 and count 2, which were originally count 15 and count 17, aggravated murder and murder. The State of Ohio and attorneys Laybourne, Kelly, and Kranek have agreed for a merger of those counts for the purpose of sentencing. The state is moving forward on aggravated murder. The indictment reads that you purposely and with prior calculation and design caused the death of Ashley Biggs. The law requires me to listen to the statements of counsel, listen to relevant evidence, consider the sentencing factors, the seriousness factors, and the recidivism factors before the court. The court has analyzed those seriousness factors and the recidivism factors. The sentencing court, pursuant to law and the Ohio Revised Code, shall consider all of the following that apply regarding the offender, the offense, or the victim, and any other relevant factors as indicating that the offender's conduct is more serious than conduct normally constituting the offense. The physical or mental injury suffered by the victim of the offense due to the conduct of the offender was, I have to consider these, whether that was exacerbated because of the physical or mental condition of the age of the victim, whether the victim of the offense suffered serious physical, psychological, or economic harm as a result of the offense, whether the offender held a public office or position of trust in the community, whether the offender's occupation, elected office, or profession obliged the offender to prevent the offense, whether the offender's professional reputation or occupation, elected office, or profession was used to facilitate the offense. I have to consider the offender's relationship with the victim and whether that facilitated the offense, whether the offender committed the offense for hire, whether in committing the offender was motivated by prejudice. The sentencing court shall also consider all the following that apply regarding the offender, the offense, or the victim, and any other relevant factors as indicating that the offender's conduct is less serious than conduct normally constituting the offense. If the victim induced or facilitated the offense, whether in committing the offense, the offender acted under strong provocation, whether in committing the offense, the defendant did not cause or expect to cause physical harm to any person or property, and whether there are substantial grounds to mitigate the offender's conduct, although the grounds are not enough to constitute a defense. The sentencing court also must consider all the following that apply regarding the offender and any other relevant factors as factors indicating that the offender is likely to commit future crimes, whether at the time of committing the offense, the offender was under release from confinement, whether the offender previously was adjudicated a delinquent child, whether the offender has not been or had not been rehabilitated to a satisfactory degree after previously being adjudicated a delinquent child, whether the offender has demonstrated a pattern of drug or alcohol abuse related to the offense, and if the offender shows no genuine remorse for the offense. The sentencing court also shall consider all the following that apply regarding the offender and any other relevant factors as indicating that the offender is not likely to commit future crimes, whether prior to committing the offense, the offender had not been adjudicated a delinquent child, whether prior to committing the offender had not been convicted of or pled guilty to a criminal offense, whether prior to committing the offender had led a law-abiding life for a significant number of years, whether the offense was committed under circumstances not likely to reoccur, and again, whether the offender shows genuine remorse for the offense. With this, Mrs. Stefanko, based upon the facts and circumstances, consideration of the relevant sentencing factors, applying the minimum sanction I've determined will protect the public and punish you without imposing an unnecessary burden on state or local resources, analyzing all the factors I'm required to analyze, including the seriousness factors, the recidivism factors, and all other factors before the court, including the following: the testimony of all the witnesses, the testimony of your co-defendant, the testimony of the victim's daughter, and your sworn testimony. Also taking into account the fact that you took the life of a young working woman who was trying to support her only child, the fact you took the life of a young Army veteran who served our country and put others before herself, taking into account that you lured this young Army veteran mother into a dark parking lot late at night while in a car with 4 young children. And this is the most egregious part. That included the victim's own daughter. Also taking into account the secondary trauma that you've caused for individuals in the community, for jurors, for court staff, and everyone else who's had to reviewed the pictures, the testimony, and everything that happened that night. Could you please stand, Mrs. Stefanko? The court is sentencing you to a term of life in prison without the possibility of parole. Please maintain your decorum or you'll be taken out of the court. Understood? Thank you. Again, the court is sentencing you to a term of life in prison without the possibility of parole until after serving 30 full years of imprisonment. As part of your sentence, you must obey all laws, refrain from any offensive conduct, follow all the rules of the department. You are not allowed to use drugs and alcohol, and you may be tested for that. You must follow all the rules of the institution. You are legally entitled to jail time credit. This will be calculated and included in the final entry. I have analyzed your present and future ability to pay costs and fees. Considering the life sentence imposed, I will waive those costs and fees. I am not imposing a fine, and I believe the state has not requested any restitution. Correct, Attorney LaPrenzi?
That's correct, Judge.
Okay. I am now going to review your requirement to register as a violent offender.